Hello, everyone, and welcome. This is our panel, International Law Online. How will the pandemic change the practice of international law? In which we will explore what might change, what has changed, and the impact of those changes as a result of the COVID-19 pandemic in the realm of international law. This session is being organized by the ASIL Midwest Interest Group, and we are utilizing a roundtable format, which we hope will facilitate a less formal conversation among our guests. And although this session is being pre-recorded, we hope to engage with you via the chat function during the broadcast of this program and in the Continue the Conversation session afterwards. My name is Brian Farrell, and I will be moderating along with my Midwest Interest Group co-chair, Professor Stuart Ford from UIC John Marshall Law School. Let me briefly introduce our guests. Juliet Sorensen is a clinical professor of law with Northwestern Law School's Center for International Human Rights, where her interests include health and human rights, public corruption, and international criminal law. Professor Sorensen is the founder and director of the Northwest Access to Health Project, a global community-based partnership at the intersection of health, human rights, and development. Professor Sorensen is a member of the ABA Coronavirus Task Force and Working Group on Crimes Against Humanity. She is the co-author of Public Corruption and the Law, Cases and Materials. Larry Shaner is a leading international arbitrator based in Chicago. He is the only Chambers-ranked international arbitrator in the Midwestern United States. A graduate of Stanford Law School and Duke University, he teaches international arbitration as an adjunct professor at Northwest University Pritzker School of Law. Until April 2017, he was a partner and co-chair of the international arbitration practice at Jenner and Block. Conglin Yu is a third-year international student at the University of Iowa College of Law. On behalf of Iowa Law, she is a member of the Jessup Moot Court Competition Team and the Viz Moot Arbitration Competition Team. Before law school, she interned for the Ministry of Economy and Industry of Israel with their Foreign Trade Division. Dr. Robert Eno is the registrar of the African Court on Human and People's Rights. He has over 16 years of experience in human rights and related fields, working with NGOs, national human rights institutions, in academia, and intergovernmental bodies. These include positions with the African Commission on Human and People's Rights, the South African Human Rights Commission, and teaching at the University of the Gambia. Dr. Eno joined the African Court's Registry in 2010 and was appointed registrar in 2012. He earned his bachelor's degree in law in his native Cameroon and holds a postgraduate diploma in human rights law from the University of Zambia, a master's in law from the University of South Africa, and a PhD from the University of the Witwatersrand. Vera Korzun is associate professor of law at the University of Akron School of Law. She researches in the areas of international trade and investment law, international dispute resolution, and corporate and business law, and teaches international law classes, including international law and international business transactions. Prior to joining Akron Law, Professor Korzun worked for Fordham Law School in New York City, Erasmus University Rotterdam, and at the leading university in Belarus. Professor Korzun holds an LLM from the University of Michigan, a master's in law and economics degree from the University of Hamburg, an LLM degree in international business law from Central European University, an SJD from Fordham Law School, and a PhD in law from Belarusian State University, where she also earned her first degree in law. I would like to welcome all of our panelists and thank them so much for joining us today. And I'd like to start by simply asking each of our participants to briefly highlight the most notable changes that they've experienced in their work in international law in response to the pandemic. And I think we'll go in the order of the introductions. So Juliet, if you are willing to start.
First, thank you, Brian, for the kind introduction. It's a pleasure to be here. The pandemic has changed my own practice, my clinical teaching, and indeed my conception of international human rights law. It has forced all of the foregoing to be virtual. The walls around me are those that are seen by students, by clients, by community partners, both in Chicago and on the other side of the world. There is an obvious downside to this as a clinical professor, which is that we seek to share with our students in order that they become not only responsible members of the profession, but global citizens, a full and multifaceted experiential learning component to their education at Northwestern. And sitting in front of your computer on a Zoom screen isn't that. I'll give you one example. I teach a course in health and human rights. As you mentioned, I direct the Northwestern Access to Health project, in which we partner with communities and organizations around the world to do joint assessments and ultimately recommendations on issues related to health, human rights, and development. We typically complete 10 weeks of Chicago-based assessments with a week of field work in partnership with our collaborator. Inevitably, the field work is a transformative experience, not only for the students from an educational perspective, but for the ultimate work product. It simply isn't possible this year. We're currently collaborating with an NGO in the Horn of Africa, and the student experience at this point is really driven by the academic calendar and will end with the winter quarter. So that's looking at it as the glass half empty. I actually believe it is possible to look at the glass as half full, but I want to be mindful of our time, so hopefully I can speak to the glass being half full later.
Thank you, Juliet. Larry.
Thank you. It's good to be with everyone today. I work as an arbitrator in international and domestic cases. As a result of the pandemic, I would say there have been three major changes. The first one is the obvious one. Just about everyone is working from home. In international arbitration, going online was a remarkably easy transition for everyone to make. International arbitration adapted quite well to working online, but it has changed life. Instead of walking to my office, I walk downstairs. The second change, which is, I think, the big one, is that the hearings in international arbitration, the trials, if you will, are now all virtual. Zoom has become the preferred platform, and it works remarkably well, much to everyone's, I think, surprise. I've had a hearing about every month or every other month. Some have lasted as long as a week or more. Some have involved very substantial amounts of money. We're talking hundreds of millions of dollars, all handled in hearings on Zoom. This is a major change. A third kind of change has to do with conferences and seminars, which are a part of the international arbitration world. Everyone likes to know one another and keep up on best practices. The major conferences and events, of course, have all been either postponed or canceled. But there has been an explosion of online programming. It used to be said that you could attend an international arbitration conference somewhere in the world every day of the year. Now, with all the online programming, you can attend several events every single day, almost 24/7, without leaving your house and perhaps without even putting on shoes. So that's a change. There have been a host of other related changes that go along with the fact that the hearings have become online. There's all sorts of guidance that has been created on how to do online hearings. There are protocols and best practices. There are model orders that get used. The Zoom test session has become a mandatory part of the procedural schedule of every international arbitration. There are new kinds of professionals. There's the Zoom consultant who assists counsel teams in how to do their virtual backgrounds for hearings and get their lighting right. There are all kinds of technical support people who now help out. So it's a new world, but it's still quite similar to the old one. And I'll pause there and give others a chance.
Thank you, Larry. Conglin, how about you as an international student studying international law?
Yeah, as a third-year law student, I will echo to what has been said. A lot of the activities have been moved online. So as a law student, we have experienced 3 semesters consecutively online. All of our class sections are conducted virtually. A lot of my fellow students and classmates report that they're having Zoom fatigue now. We tend to feel less engaged in our social environment because we're having less face-to-face meetings with the other people. I'm also doing just up competition and Avi's arbitration competition this semester. Both of these 2 competitions are moved online this year. So we have no opportunity to meet with anyone in a physical setting. However, we do have the unique opportunity this year to meet with international judges who live in a different time zone and who are able to show up due to the technology assistance. And I'll pause here and leave the time to the next speaker.
Thanks, Conglin. Dr. Eno, I think we are all excited to hear a bit about how the African court has adapted to this, and in particular, what it's meant for you in the registry. I imagine that you're sort of in the center of a lot of these changes. What's been most dramatic?
Yeah, thank you, Brian. As the registrar of the court, I deal mostly with case management, ensuring that parties that come before the court have their cases processed in accordance with the rules. However, when the pandemic struck, it took us by surprise because there are so many things that were not in our rules of court that we realized that we could not proceed without an amendment of our rule. For example, we had to organize virtual public hearings, but we did not have that in our rules. So we had to adopt new practice directions to provide for virtual public hearings. Secondly, we couldn't invite witnesses, we couldn't invite experts because of the pandemic. As a matter of fact, since the pandemic started over almost a year now, we have not had any public hearing. Unfortunately, some states are taking advantage of this. They claim that they are not ready to even attend virtual public hearings because they don't have the staff to prepare cases. So we've not been able to organize public hearings, and this has affected quite a number of applicants before the court. We have organized virtual sessions where the judges sit in their different countries and attend to sessions. This has been quite successful, surprisingly, because we've been able to deliver a number of judgments with the online sessions. So far, we've organized 4 online sessions and have been quite successful. But the challenges have been a bit enormous, challenges of connectivity. There are days where we may lose close to 2 or 3 hours because of internet connectivity. And this has been quite challenging somehow. We have been able also to facilitate the process of online sessions we've taken steps to digitalize most of the pleadings that come before the court so that we can send them to the judges. Because ordinarily, if the judges are meeting physically, we print all the documents and give to them. But now that they are meeting virtually, we have to digitalize all the pleadings and send to them. So we have installed what we call an electronic case management system, whereby judges can directly access the documents and be able to treat them. So this is one of the advantages of the pandemic, because it has pushed us to be able to digitalize most of the documents. And we have also introduced an e-filing system whereby applicants can submit their cases electronically. And we are still developing the process to ensure that applicants can also, with time, monitor developments of their cases through this e-filing system. As I indicated, the pandemic struck when we were not prepared, and we had to take certain measures. For example, all the deadlines that we had given to parties to respond to cases, we had to suspend those deadlines because of the pandemic. And for over 3 months, we gave a grace period to most of the parties not to be able to respect those deadlines because of the pandemic, because we realized that many offices were closed and the parties before the court did not have the opportunity to deal with matters before them. So it has been quite a challenge for the court, but after almost a year, we have been able to adapt to the situation, and the court is dealing with business now in an almost normal manner, even though it is virtually. So we believe that although the pandemic caught us unawares, it has given us the opportunity to be creative, to be innovative, and put in place certain measures that will help us to deal with such uncertainties in the future. Thank you. I'll end here, and then in case of anything, I may come back. Thank you.
Thank you. Very interesting to hear how that has impacted the court. Vera, can you give us your perspective teaching international law?
Yes, of course. Thank you for inviting me and giving me a chance to share my experience. So I think I won't surprise anyone by saying that we also moved online. And in fact, I'm approaching my 1-year anniversary of being entirely online. And as I'm thinking about changes during this year, I group them into 2 bigger groups. So on the one hand, definitely mode of delivery of mode of instructions have changed. We don't have a Zoom fatigue because we use 2 other platforms. And this is, I think, to support what prior speakers have said. People are much more equipped nowadays with technologies. They are easily moving through different technologies, upgraded the internet. So, of course, we also have our problems with connections. But overall, I think moving online was surprisingly smooth. Talking about mode of delivery, I can tell that, for instance, I teach international negotiations class, and I found it's beneficial sometimes when it comes to working in small groups. We call them breakout sessions. I'm able to break my class in 4, 5 people groups, and they are recording their performances. So different rounds of negotiations, you can go and watch them and analyze as needed, and students find this useful. And in real life, you wouldn't be able to do this. Normally, they would be just, doing these negotiations in separate rooms. So technology helps us in this sense. And moving into the second group of changes, it's of course content. I mean, I'm still using the same books, but I'm relying on a vast majority of events and things which are happening online nowadays. So I can assign, for instance, a video recording of a prior session from, ISIL meetings. I can invite my students to go and join a workshop that is being organized on the spot. I hear students are now participating in online competitions. And so in the many ways, the content of delivery, the mode of delivery made the content more accessible. Being in the Midwest, it might be expensive for my students to fly, but if events are offered in a different part of the world online, fee-based or free of charge, students now have many more opportunities to attend those. And from the international law perspective and learning those things, I think it's a huge advantage. So I'll stop here and, let other people reflect. Thank you.
Great, thank you very much. So Vera's thoughts may sort of tee up the question I was going to ask next, which is, of the changes we've experienced, which of those do you expect or perhaps hope to persist after the pandemic is over? And this is not a question for any of you in particular, so whoever wants to answer can go ahead.
I'll respond briefly, Stuart. I think that as Vera said, for many opportunities, we had previously moved into a digital age, but we had not fully conceptualized the possibilities of the digital age. The pandemic forced that to happen and forced us to see what was possible in a world with connectivity. And so I believe that many of the opportunities that have been described, virtual hearings, virtual conferences, that seem to have been, not only have gone off without a hitch, but actually been enhanced by digital participation, will remain in that format. My concern and what I want us to be mindful of is that there are individuals, groups, and institutions who remain excluded because of the digital divide. Dr. Eno discussed the inefficiencies that his court has had to face in light of connectivity delays and parties who don't have access to high-speed wireless. No doubt there are people who might have sought to participate in one or another of the forms we've described in person, but simply are unable to do so digitally. And so I hope that as we emerge from the pandemic and retain many of these digital opportunities, that attention is paid to those people who won't be able to participate in digital opportunities going forward, just as they haven't during the pandemic. If that is remedied, and that can be done in a range of ways depending on the place, the setting, and the people that we're talking about, then I think, as I said in my opening remarks, we can truly see the glass as half full and be in a world where the practice and the scholarship of international law has the potential to actually be more inclusive.
That's a great point. Do any of our other panelists want to speak about the changes they hope will persist?
Yeah, if I may, and just to concur with Juliet, it is very likely that the online public session of the court will continue even after the pandemic. As a matter of fact, the rate of the success that we have achieved has led the African Union to want to reduce the budget of the court, noting that we are very successful with online sessions, and there is therefore no reason to give us money for physical sessions. So it is very likely that the online session of the court is going to continue, because we've realized that with the online sessions, the judges are focused for a particular period of time and deal with the business of the day and leave. And we have been quite productive, and as a matter of fact, this year, 2020, we delivered more judgments using online sessions than we have ever delivered at any one time. Yeah, So in my view, it is something that I think is going to continue. And secondly, the introduction of the electronic case management system, which has an element of e-filing, is something that we are going to enhance, and is something that will continue, and which we think it is good for case management and good for parties before the court. Thank you.
Yeah, thank you. Larry, I think you have something you wanted to add.
Happy to jump in following on what Dr. Eno was talking about. Virtual hearings work well in international arbitration, and they are going to be here to stay, especially for smaller matters. The cost savings of not having people have to jump on airplanes and fly halfway around the world when the proceeding can be done online is very attractive. But I don't think that hearings, in-person hearings, will go away for larger matters or even medium-sized matters. What I think we're going to see and what is expected in the field are hybrid proceedings, which are partly online and partly in person. You know, for example, the 30-minute witness testifies online. The witness who is the 2-day witness is flying in and will appear in person. Another model that we are starting to see and likely will persist are participants taking part in clusters in different locations, all of the arbitrators in one location, the claimants, their witnesses, their clients in another, and the respondents in a third. I've already been seeing that happen in some of my cases. We're going to see hearing centers that some cities have adapt to support virtual hearings and hybrid proceedings. They are already upgrading their video conference capabilities, for example. But I just don't see in-person hearings going away. There's something that's lost by not having the in-person immediacy. Arbitrators, you know, have more difficulty assessing witness credibility online than you do when you can see a person's entire body. You know, experts report they can't tell if they're getting across to the arbitrators because they can't really see them entirely. Arbitration tribunals, 3 arbitrators, don't have the opportunity online to build up the same kind of chemistry that they build up when they're in person during breaks and in meals and so forth together. And you know, they lose that opportunity to sort of to build up a rapport and trust with one another that helps them come to a decision. Other concerns by doing everything online that will remain are, you know, concerns. They're ethical issues. Is the witness who is purportedly testifying alone really in a room with somebody else who is giving them directions? Are there notes somewhere in the room or other aids to testify? You know, we deal with that somewhat, or can, by having witnesses do 360-degree sweeps with their cameras and things like that, but it's just not quite the same as an in-person hearing. So I think hybrid proceedings are where we're heading, and I echo the view that has been expressed that the pandemic has pushed us up the technological digital learning curve. It probably has accelerated things that would have happened anyway, and that it has forced us to embrace these changes in the longer term is a good thing.
Conglin, can I get you to jump in here? Earlier, you talked about concerns amongst your colleagues about Zoom fatigue. So can we really go online for everything, or are there limits to how much we can do online?
I think there are limits to what we can do online. I will agree with what Mr. Shaner has said. Like, there are limits to what we can do, because we can only build that rapport and that trust with people with whom that we can meet physically. As a student, I would hope that in the future, we can go back to the old days where we can have the class sections face-to-face in person instead of virtually. because that will help with learning for sure. And I feel grateful for the unique opportunities presented due to the technology that we have, because we have so many activities going on online every day. All the conferences, all the events, all the seminars, I can join in to any of those at any day. I don't have to travel or, do anything additional besides signing up. So that's always a plus as a student.
I can jump in as well.
Sounds good.
Yeah, so I agree with what has been said in terms of moving into some sort of a blended model. And I mean, we are at the law school, we are still subject to the ABA requirements, and this year was different. So I think there were various exceptions granted to allow us to move entirely online. In normal days, it wouldn't be possible under the current rules. And so I think some sort of blended or mixed model will persist. The question is in which format and shape, right? We can talk about blended in terms of online versus, live classes. We can talk about blended in terms of what we call synchronous live online versus pre-recorded online mode of delivery. And as I'm thinking about that, we are right now at the law school trying to get some data in terms of what are the preferences that our students have. And I teach evening division. And I think the preferences for evening division, non-traditional students are different as compared to day students. And so as I'm thinking about that, it almost feels specifically for, teaching that where the classes are offered, as long as we have some good, solid, developed online programs. So where it becomes less relevant, of course, there are still reputations, right? Different schools and different regional preferences that students might have. But to the extent that the programs are of solid, strong format, they have been developed and run online, there is a support. I think we'll see more students enrolling into some sort of online blended model in different parts of the world, and those programs were not available, and they were simply not available before. The bigger challenge I see, I mean, in terms of lectures and maybe seminars, they can be done online. How to ensure that students also get internship and clinical experiences, I think.
We've lost Vera briefly. I think
talk to this effect more, but to have real ground.
I had something like this happen in a hearing I was doing last week in the middle of a witness testifying, and the witness just continued, and we, had to replay, several minutes of the hearing. This, would be one of the reasons why I think in-person hearings are not going away.
We lost just a few seconds of you there, Vera, but yeah, an illustration perhaps of the limits.
I was just saying that internships and clinics are harder to organize online. And I think, Juliet, would be better to speak to this, but it's a challenge. But I think online, in one way or another, is here to stay.
Yeah, I find it interesting. I made a note, Juliet, I think you used the term force, and then Dr. Eno used push, and then Larry talked about both pushing and forcing us into this new reality that maybe is just accelerating some changes that needed to happen. And along those lines, I'm curious, here I am in rural Iowa, and Dr. Eno's in Arusha. Curious to think, do these changes have the potential to decentralize international law, the practice of international law? Dr. Eno, you've described the ability of lawyers and litigants from across the continent to participate. Conglin, Vera, you mentioned the increased opportunities for students in smaller markets in the Midwest to participate in international events without getting on a flight. What does this mean? Is international law still going to be concentrated in DC, London, or is there a potential that we'll see a decentralization?
Larry, I'd be interested in your insights on this. My short answer would be, I think it depends. It depends on the nature of the practice and engagement.
I'm going to go with it depends, but I'm leaning towards the unpopular view, at least in international arbitration, probably not so much in terms of where the cases, international arbitration cases, are seated and where hearings take place, and where the participants, at least their law firms, are located. What's happening in terms of decentralizing is that everyone from anywhere can take part in the seminars, can get access to the information, can virtually network. But that is different than actually doing the work and getting hired and appointed. The way I think about this question is maybe in two ways. Will law firms in non-traditional centers start to get more international arbitration work? And my instinct is likely not in any dramatic way. While the lawyer, because clients are going to continue to value experience, and they're going to continue to go to, especially for their major matters, lawyers and firms that have handled many of these matters before. And I just don't see that changing. Now, the lawyers at those firms and the arbitrators they appoint may choose to live and work anywhere. I could do my job as an arbitrator from anywhere, literally on the planet, as long as there is, good internet connection. But I'm still going to be probably, working with firms that are in the major centers, and the hearings are likely to be in those. I mean, the other way to look at this is, and when I say, major centers in the U.S. for international arbitration, it's really New York and Washington, and then to a lesser degree, we're talking about Miami, Houston, Chicago, and then maybe Atlanta, and some other practices are scattered through the country. Will the seats for the cases and the places of the hearings change? Again, I think that the considerations that point to those places for arbitration are going to continue after the pandemic. Parties and counsel are going to look for pro-arbitration legal environments where the courts have been tested and are trusted not to interfere with arbitrations that happen in their jurisdictions. And then the practical considerations are likely still going to be important, because at the time that parties enter into their contracts and they specify the place for the arbitration, they won't know if the hearing is going to be in person or virtually. So they have to plan for the possibility of an in-person proceeding, which means, is there a major international airport so that everyone can get there? Are there good hearing facilities, nice hotels, good restaurants, local lawyers who know something about international arbitration? All of those factors still point towards the traditional places. So I think people can live anywhere, that they can take part from anywhere, but I think that the work and where the cases are happening is more likely to remain in familiar patterns in the near and medium term.
Can I? I just want to concur with what Lawrence is saying, because for the African court, for example, the seat of the court will remain in Arusha. It will never move. However, it is possible that you can access the court for an online session from anywhere. Anywhere in the world, you can access the court. But the seat of the court remains in Arusha. If we are having physical sessions, you may want to travel to Arusha to attend the court session. But if it is an online session, you can access it from anywhere. Does that mean international law will be decentralized. I doubt because international law is a specialized practice. And if you are not familiar with the processes of maybe accessing the court, that will not make you an international lawyer to be able to access the court and practice before the court. So in my view, I'll be hesitant to say that one of the effects of the pandemic is a decentralization of international law. Yes, you can easily have access to the court wherever you are, but the seat of the court will remain the same, just like the seat of other institutions will remain the same. So I just want to concur with what Lawrence is saying, because that is a practice of the court as well. Thank you.
At the risk of jumping in here out of turn, there's even a risk that the reverse will occur, and that the established players will be able to play in more places. In other words, if hearings are going to be online, why not hire that top practice firm in New York or in London to represent you anywhere if it's an online proceeding, or appoint the most prominent arbitrator in the world for a matter anywhere if they're simply going to have to appear online. So it could cut both. It could have the effect of making the well-known players, allow them to play in more places rather than allowing the work to gravitate out into lesser known, if you will, parts of the lesser known jurisdictions.
It's an interesting point, Larry. Thanks for sharing that. Vera, did you have something to add?
Yeah, I tend to agree with what has been said. I don't feel that pandemic specifically will rearrange the centers of international law as we know them today. As I'm thinking about that, I'm also thinking that we are focusing here on public international law, and then we are focusing on international dispute resolution. My students, for some reason, tend to assign immigration law to public international law field. I don't agree with them, but in their mind, those are closely interconnected areas. Maybe, when you think about refugee protections and then move into immigration, this is how you connect those two. And there has been already immigration practice in the area, so I don't think it will be impacted by the pandemic in my case. International business transactions, to the extent that this is international law, private international law discussion, and that this area was decentralized before, it probably will stay decentralized. But moving into, areas where you gravitate to bigger courts and centers of public international law, such as, The Hague, Netherlands, and since the courts will still remain there, even if you have hearings online and people live in the neighborhood, I feel that you have to be in these fields and areas of the world before you can practice and really get experience there. And so I don't think, generally speaking, that pandemic will bring broader changes here for us. It's indeed easy to educate our students in these areas because we have online mode of delivery, but they still need to go and practice and work in the world, as Larry has suggested. And it's harder to do it in the bigger areas while being located in the Midwest.
Conglin, do you have any additional thoughts on that? I mean, you've described some of these opportunities to participate with a broader range of other schools, other students, and at the same time, you've noted the lack of ability to interact socially and have those deeper connections. Can you reflect a bit on what Vera said?
Yeah, I think I agree with the statement that the pandemic might not lead to the decentralization of the international law. It is true that we can have more exposure to the content related to international law by virtue of technology. However, at the end of the day, the practice of international law will still depend on political events and marketing events, and some of which they're only going to happen in certain parts of the world. Yeah, so besides these things that we have talked about, I would also bring up the risk of these online events or hearings or trials conducted online. We might have privacy concerns where a lot of these things are open to the public, and everyone will have to turn on their camera while they're speaking. As a student, we're doing all of the final exams when we have to turn on our camera, and an AI, artificial intelligence, will be watching over us. So yeah, so in all of these aspects, we might have concerns about privacy and all these issues.
So Vera, I have a question maybe for you. So I teach night classes, and during the pandemic, I've switched to a flipped classroom where I pre-record much of the material and only present about a third of the material live, the discussion portion of the class. And my sense is that for many night students, that's actually a preferable model to the traditional model of spending 3 hours in a classroom once a week. What's your experience with that? I see Juliet nodding too, so she may have something to say about this as well.
Yeah, so because of the way we schedule classes, in the beginning of the spring semester, will be an example. My students didn't know whether I will be teaching online with the proper distancing, in person with the proper distancing or online, and that they could pick and choose whether they would prefer to come to school or not. And so right now I can tell you that 30% of my students still wanted to be in school having live classes, and 60 wanted to be online. So it doesn't answer your question in terms of recorded or pre-recorded. It only indicates, based on my small sample, what is the preferences in terms of live versus online. But then moving into pre-recorded, I don't know. I feel there is students want this in-person interaction that live classes give. And I think at the end of the day, evening students want to have a healthy mix of pre-recorded lectures and assignments that they can do on their own, and then having a chance to come into live class, albeit online, where they can chat, when they can talk, when they can see and hear others, compare themselves against others, and have the best mimicking of the real life that we can have. And so I think this would be my answer. And of course, pre-recorded takes time. We have elaborate program of training. You have to be careful with font. You have to make sure that you satisfy all the rules in this sense. And so I think some of us who wanted to have pre-recorded lectures simply didn't have time yet, but we are extensively discussing this. And I personally want to move part of my public international law clause in pre-recorded mode.
And Juliet, did you have something you wanted to add as well?
Yes, I did. A couple of things. So I too have experienced an asynchronous hour, in building an asynchronous credit hour. I taught a course in the fall on contact tracing, law, and ethics, and took the decision that the asynchronous hour would be interviews with a range of experts. It was one of the glass half full instances, because I'm fairly certain that the contact tracing, law, and ethics experts whom I interviewed for that asynchronous hour, and as Vera said, of course, there's a transaction cost. It does take additional time and effort, but they were from all over the country, and it simply would not have been possible to do that in person. That said, I do agree that students want the closest to an in-person experience that we can approximate in that setting. And I myself think that as an educator, I've gone through something of a learning curve in teaching via Zoom, and I think the students have as well. I have found this semester that their level of focus is high. Their desire to interact and engage practically leaps out of my computer screen. And so I think that they have not only accepted, but adapted, and in many instances thrived. The breakout rooms with the help of a virtual course assistant have been very convenient. I too have been doing for health and human rights night classes, the 3-hour block for some time. Originally, it was for logistical reasons because that course is open to law, business, and public health students, all of whom have different curricular requirements and schedules during the day. And so it was a pretty easy decision to take to make it virtual this year. Whether that will continue, again, ultimately, it's not totally up to me. It's up to my employer, the law school, and also, of course, the ABA, which has been regulating in the past the amount of remote teaching that law students are permitted to experience pre-pandemic. So I'm curious what the ABA, as the accreditor of U.S. law schools, will decide with regard to remote teaching as we emerge from COVID-19.
Those are all good points. We're coming up on the end of our session, and I want to give each of our speakers a chance to offer some final remarks if you'd like to. So if anybody has any final thoughts, please take this opportunity to share them with us.
I would say that the COVID-19 pandemic, although took a lot of us by surprise, has also presented quite some opportunities to us to be able to use technology to advance the course of our business, especially for us at the African Court. It has opened our eyes to quite a number of issues going forward.
I have two concluding thoughts. One is just an observation that with some people being vaccinated and others not, there has been created a kind of a competitive advantage for older arbitrators who have been vaccinated, which they are going to exploit for the next few months. That's a little bit tongue-in-cheek, but that's an advantage I've told some of my older colleagues of being an older colleague. But on another point is this, that while we're able to connect virtually, and while virtual conferences and virtual seminars are great, there hasn't yet become a good virtual substitute for the conference cocktail party or the after work drink somewhere with a nice view over a charming faraway city. And so I think we all look forward to when we can get back out into the world together.
I'll jump in here, and I just want to say, I think on behalf of my students and myself as a scholar, I definitely, welcome the initiatives that gives me insights into the practice world. And this includes what Dr. Ina was describing with regard to electronic case management system. And I don't know to what extent it's currently already accessible for students, for instance, or researchers from other parts of the world. But to the extent that it is, it's a great window for us into the practice. And to Larry, if I may, well, I'm just looking forward to have as many public hearings. I know international commercial arbitration is a difficult case, but at least for investment arbitrations, again, from the student's perspective, how else you would learn how the hearings are conducted. This is just unbelievable opportunity for them. And to the extent that those hearings are available, I always keep an eye on them and try to let students know that this is happening. So please keep doing this for our benefit. Thank you.
Conglin, did you have any final thoughts?
Yeah, well, I miss the old days where I can shake hands with people. I do acknowledge that we have this unique opportunity of a lot of resources that are available to the students online, and I encourage all the students to take advantage of this.
All right. Well, I want to thank all of our panelists, our distinguished panelists, for their thoughts and insights into the effect of the pandemic on the practice of international law. Also to thank all of our attendees for coming and listening to us. I know this has been pre-recorded, but we appreciate your time to listen to us. And you can continue the conversation afterwards. Some of us are going to be available for discussion following this event. So if you click on the Continue the Conversation button, you will be able to talk to some of these panelists and Brian and myself after the event. All right, I want to thank you all very much for your time and for your thoughts, and thank you for participating.
Thank you very
Thank you.
much.
Thank you very much.